Get ready for the dictation. Start. The contention that since the preliminary written examination was only of qualifying nature and the writ petitioners had already qualified and were thus not prejudiced cannot be accepted for the reason that if certain act is impermissible in law, as in the present case service rules do not permit rounding off, such an action cannot be approved on any count. The recruitment board, by rounding off marks, has acted in derogation of the statutory service rules. In fact, such an action has resulted in allowing ineligible candidates to appear in the next stages of selection process, out of whom many are said to have been finally selected. Thus, as a result of the recruitment board having resorted to rounding off, ineligible candidates were allowed to participate in the further selection process, which cannot be the intention of the law. Suitability of a candidate for appointment has to be judged only amongst the eligible candidates and not amongst ineligible candidates. In the instant case, even ineligible candidates have been permitted to participate in the selection, inasmuch as Rule 15D of the Service Rules in unambiguous terms provides that the candidates who secure minimum 50% in the preliminary written test shall be declared successful. However, the candidates securing less than 50% have also been declared successful, which is contrary to the prescription contained in Rule 15D. Violation of any statutory prescription thus expressly vitiates the process of selection. By taking recourse to rounding off, the recruitment board has violated Rule 15D of the Service Rules 2008. Hence, we have no hesitation to hold that the selection process got vitiated on account of this score alone. We thus do not have any reason to take a view different from the one taken by the learned single judge, that rounding off percentage of marks secured in the preliminary written examination was not permissible. Another issue which arose has been considered by learned single judge in his judgment and order under appeal is in relation to the manner in which rule of horizontal reservation for special categories such as women, dependents of freedom fighters, and ex-servicemen has been applied in the selection which was under challenge in the writ petitions. It was contended on behalf of the writ petitioners that the recruitment board had applied the rule of horizontal reservation, which has resulted in putting all the candidates selected on the basis of horizontal reservation in the open category, and that none of them were placed in the reserved categories, which was in violation of Section 3(3) of UP Public Services Reservation of dependents of freedom fighter, physically handicapped and ex-servicemen Act 1993. It was thus contended that such application of horizontal reservation is in violation of Articles 14 and 16 1 of the Constitution of India, as also the law declared by Honorable Supreme Court in the case of Indira Sahni versus Union of India and others, 1992, Supplementary 3 SCC 217. The aforesaid issue has already been considered by this court in the case of Ashish Kumar Pandey and others versus State of UP and others, writ A number 37599 of 2015, wherein it has been held that the process resorted to by the recruitment board, by which horizontal reservation has been applied during selection in question, is illegal, and the selection has been quashed on the said ground alone. The judgment delivered by learned single judge in the case of Ashish Kumar Pandey has been upheld by the division bench on the aforesaid ground. Stop.